Hello, everyone. It's Joyce here.
And Soshana.
Thanks for joining us again. Continuing our conversation about the trust, estate planning, we'll have an estate planning attorney, Holly, joining us again.
Hello.
Thanks for coming.
Yes, thanks for being here.
So what we talked about, how did we end the conversation? It was about the trust, that you're going to talk about different types of trust, right?
Yeah, correct.
So let's start with that.
Well, so we talked about at the last session about, the will and how it has to be probated. Right. You can't ignore that for most people. And you asked about the scenario of, the ideal situation. Right. When somebody dies. What is
good
that?
Memory.
What does that
look
look
like? I forgot.
Yeah, what does that look like for people? So for a lot of people, the holy grail is the trust. Everything's taken care of. They create a trust document to make sure that all the assets, including property, vehicles, automatically, instantly, privately, no further cost, no one fighting or objecting, is transferred by that one document, the trust document. I consider the trust document where you designate who gets your assets as a title transfer document. Okay. For your vehicle, properties, any accounts that you integrate with the trust. And you don't have to go to probate court to do that. In the United States, the trust document is recognized to transfer automatically to whoever you designate in your document instead of probate court with the will or no will.
Is that sort of like you making the decision so that the court doesn't have to?
Yeah, and you don't have to go through court. So during your lifetime, while you're healthy and competent, at least competent, you create a trust document with an expert lawyer, designate who's going to get your assets, who's going to distribute the assets on your behalf to these people, and if you've got minor children, who's going to manage it while they're minors. And as soon as you die, that successor trustee takes over and follows to the T the instructions in your trust document, your wishes. It's that simple.
Is a trustee the same thing as an executor of an estate?
In concept, yes. So the executor is the one appointed by the court that you recommend and state in your will, so long as there's no objection by anybody. In a trust document, we call that person the trustee, the successor trustee. And that's the person, without probate court, is going to step in automatically and have legal authority to gather all your assets and distribute it according to your instructions.
Okay. All right. Good thing that Joyce is here, because my next question has to do with taxation.
Before you get to that,
Okay.
How about hold on to that thought?
Let's never talk about taxes.
So then, last time we talked about anybody can open up a probate court case, right? So you have everything put in your trust, let's say.
Correct.
But somebody can still go to the probate court and open it.
With the trust?
No, not with the trust. Let's
Not
just
with
say.
the trust.
Because they don't know if there's a trust. Even the trust is in existence right now, right? So let's say the case, whoever's left, think that they own something, but they realize there's nothing coming in, or whatever the case may be, or even the creditor. They can go to a probate court and open the case, right? So how is the trust then carried? In other words, people say this, I've put everything in my trust, but somebody can go to the probate court still. And how does that get handled then, I guess, is a question.
When there may be a trust out there.
Right.
So the probate court has no jurisdiction over assets in the trust transferred during someone's lifetime.
So they actually have no control, no nothing, so they're not going to be able to do anything.
No.
Okay.
That jurisdiction remains depending on the state and the state or superior court. The only way you can undo a trust is if you prove in state or superior court that it was done by fraud, undue duress, incompetency. When that's undone and you prove that and litigate it, which by the way, it's very expensive, then the assets then have to go to probate court because there's nothing, right?
Gotcha.
There is a pour over will, like you pour a drink, P-O-U-R, that always is a companion when you sign a trust, where it just states merely that, hey, if this trust is invalidated or I forgot to put something in the trust, then I still want it to be distributed in my trust or to the people I designate still listed in the trust, so long as the person was competent when they did the trust.
Okay.
So some people forget to put everything in the trust.
Yeah, that happens a lot too.
Yeah. So we can't avoid probate with the asset they forgot, but it's such an expedited procedure when all we have to do is take it out of probate and put it in the trust. We don't have to go through the long, drag-out process of who gets what.
So the question you may have is like, you talk about personal belongings. What
Right.
happens to the personal belongings?
Right.
So the personal belongings, for example, piano, computer, whatever case may be, that can be part of that
Trust document, yes.
Right, and also, like if it's not included in the trust document, that can be included in
The pour-over will.
pour-over.
Correct.
That's kind of
So the contents in the house and anything on your body, that's what she's referring to as a tangible personal property.
Okay.
You can't put account numbers on your ring,
Right.
That's
right,
right.
and your furniture.
Right.
And so the way we designate it, you have to state in the trust document who gets those tangible personal property.
Oh, okay.
And
That's a lot of work.
well, that's why you want to get expert advice to make sure that you get everything integrated with your trust when you
Okay.
do a trust. We do a lot of probate courts now with do-it-yourself downloadable
Yes.
LegalZoom trusts, because people are doing these trusts, inserting their names, and they don't understand there's a lot more involved in setting up a trust and also maintaining it.
That's right. So it's kind of like this when you're the only one creating a company, right? And you use this downloadable, bylaws sometimes or agreement, and it's you and your wife, husband, wife, whatever, right? But like if you're dealing with partners, a third party, that's when people definitely go to the attorneys, right, to
Yeah.
draft agreement and things like that, because that's when you're like, I want to make sure that we all are covered.
Yeah,
Right.
a third party is going to hold you accountable.
Right, exactly. So there's
Right,
that.
that
Just
makes
like that, I think, but then you've seen it a lot of times. People come to me and say, I only have one child, but it turns out they have multiple children, things like that. So when you pass, right, that's when everything is coming out, right? And if you didn't prepare correctly or as you should, then that's when when you think there's nothing there to be fought for,
Right.
but things can really go crazy.
I always say ignorance is bliss until it's not.
Right.
Then the world implodes.
Yeah.
And your family you leave behind has to deal with that mess, and that's the memory that you leave them with.
Yeah.
And parents, you tell your children to be organized, be responsible, take care of
Right.
everything. And
But
then,
you're not.
But then when you pass away, the children are like, you didn't take care of anything.
Right.
That's right.
Right.
Yeah.
There's that moment too. Like, God dang it, Mom and Pop, you always told us blah, blah, blah. Like, look at you.
There's been people in our life, my husband and I, life, that we've seen them be organized as far as their estate planning, where you can tell that everything like worked nicely and flowed nicely, and then those who did not, I think there's education that's really needed, because it happens too often that people are not prepared, and it like leaves people feeling like the people that are left behind feeling terrible and not agreeable with each other.
Now, that happens a lot.
And in probate court, guess who those people are that are not agreeing? It's sisters and brothers.
That's right.
Okay.
It's step-parents. I mean, it's family members. All of a sudden, probate court brings out the worst. They're paranoid of each other. They don't know what's going on. They don't trust the executor. Most people fighting in probate court, they got along perfectly well while their parents were alive.
That's
Right.
true.
And then when probate opens up and we're dealing with assets, that family dynamic breaks down
Wow.
It
because
really
you're in
does.
court. And unfortunately, the court system fosters pitting you against each other.
Mm.
Unfortunately, that's just the system we have.
Mm.
And so it's ripe for that. And most of the people fighting in probate court is family members.
Yeah, that is the case. Like, otherwise, you have no
sad.
interest
That's
in that.
unfortunate.
Yeah, it is fortunate, but I think it's not only the money though that they're after. Now that the parents are gone, all the emotional baggages and all the
Sentiment.
relationship issues and all that come out
Yeah.
with
You're
them.
right. You are
with them.
absolutely correct.
Yeah.
All of the little issues that were percolating
Right.
amongst brothers and sisters and family members
Yeah.
come up
Yeah.
to the surface in probate court.
It's interesting. In my family, we haven't had a lot of death in our family. Like, that I can remember. I remember my uncle passing and my grandmother that passed away maybe, I think it's been 5 years or so ago. And it's like, you don't, like, in my mind, I never thought about death. Like, that it wasn't something that we considered because we just didn't live through that. And now, as I'm getting older, it's like, oh, I have to think about these things. We don't have children. So what happens to our things? What should we do? Should we, like, spend up all our money and enjoy, what we've worked so hard for?
Enjoy.
Should we think about other family members as the nieces, nephews? Those are things that I feel like we need to, like, really think through, especially since we have a growing company.
That's true. That's a main concern. And the thing about it is, even though you have no children, you don't ever want to outlive your resources. Right? So the idea is you're going to leave something behind. That's the idea.
Everybody
Right.
does.
Right.
So you have to take care of that.
Yeah.
You know what? Now, well, how about we talk about, since you mentioned that, how about we talk about cases? Let's just pick two
Okay.
cases. One's a simple case.
Okay.
One's rather complicated. So
Okay.
I think that way people can kind of relate and, okay, which side am I on? So
Okay.
what do I need to do? This
Okay.
may give a better idea in terms of, okay, what's my next action should be.
Okay.
So
I like that.
first case is like simple. You hear this all the time. You're in real estate industry,
Right.
so you hear that a lot. So I live in Georgia. I have a primary house. I have a couple of cars. I have a couple of children. I have a retirement account, for example, 401k. I have an investment account, but that's about it. Do I need to go see you?
Are you married?
Yes.
Okay. Are your children minors or adults?
Adult, let's say.
Okay. So again, number one, go get a consultation with an attorney to know what all the different options are. And here's one example of why. So your one primary property in Georgia, and it's different in each state. Married couples on properties, if only one spouse is on the property when he or she dies, we're dealing with probate. If you're both on title, then it depends on whether you have the tenancy in the entirety with the right of survivorship language.
Right.
A mouthful. But that language has to be in there in order for when one spouse dies, the other spouse automatically inherits the deceased's half without having to go to probate court.
Okay.
So again, I mentioned we do a lot of probate courts for widows to get clear title so they can downsize because they don't have that tenancy in entirety with right of survivorship language on the deed. And by the way, it's not up to the real estate attorney to tell you at closing to give you that estate planning advice.
Right.
Because that's an estate planning
Right.
advice.
So people assume that it is done that way. The title is, but a lot of times
But it
I've
is done
seen-
correctly. You're both on title.
Right, but not with that survivorship thing.
Yeah, which is more of an estate planning issue.
Right.
Like what happens when you die.
Right.
So that's why I always say get expert advice and the right one. Because a lot of lawyers don't know that. CPAs, financial advice. How would you know that if you have not had experience probating all
Right,
of that?
exactly.
So while it seems like a simple question, there's a lot of what ifs even
Right.
involved with that.
That's right.
And the last piece, so again, that probate can or cannot be involved in that, depending on. And even when there's right of survivorship language, what happens when the last spouse dies on title?
That's right.
Got probate court. Now, all of this can be resolved if you put it in a trust, because it doesn't matter who dies first or last.
That's right.
We don't need that additional language. So then the last piece is a lot of parents want to make sure that whatever they give to their children at their death, they want to make sure that their divorces or their lawsuits or creditors don't wipe out what you give them.
Right,
After
the
your death.
lifetime savings, basically.
Yeah, because your assets passing to them, even in a will or the trust is not structured right, if they get a divorce, where does half or more of your assets end up?
That's right.
And divorce is over 60% in the U.S. And it'll probably most likely happen after your death. Your children will, age, and then they realize, looking at their spouse, I want a divorce. And then divorce is really about assets. Who gets what?
That's true.
And if you've got children, there's custody issue, but primarily the fight is over assets. And a lot of children lose their parents' inheritance because the parents didn't realize that there's ways to pass assets to children protected. And so that simple question,
I know it's not simple.
if you don't know all of these what ifs, you really don't know how to plan for it.
Yeah.
That's right. That's where the expertise come in. And I think even for that simple case, because I deal with a lot of Korean Americans and also different Asian ethnicity groups as well. And so this is what they bring in. This is all I have. My tax return is simple, exactly the same question. And I said, okay, do you have assets in other countries? Oh, yeah.
Oh,
You know what I mean?
yeah.
And a lot of people have that.
Right.
They have a little house there or bank accounts or financial accounts. They do. So until I ask them, they're like, Joyce, my tax return is so simple. I only have one W-2, for example.
Right.
But there are different implications. And I have to ask those questions.
Yes.
It's just exactly like that. You think your
Yeah.
life is so simple.
Yeah.
When you actually unfold it, you discover or you find, oh, there's this, that. Until
Right.
you're asked those questions.
Right.
You don't know it's relevant.
Right.
Correct.
Yeah. So
I'm in the same boat as you. A great majority of our clients are Hispanic. Same thing. They have a lot of assets in another country.
that's right. They're still buying too.
Yeah.
Yeah, because a lot of people are thinking, well, I may go back after I retire, right? And you travel so many times too during the year because of different reasons, and you buy different assets there.
Right.
You don't even think about it when you come here. Like, do I have to report it? Depending on, you know what I mean. So
Yeah. And a lot of people come from different countries where the equivalent of a will is sufficient. But it's the exact opposite in the U.S. It's a start, but it shouldn't be your finish line
Got it.
because you didn't take care of majority of the stuff. But it's a good start.
Oh, I see. So maybe people coming from different countries may have different ideas about this. How the system.
Absolutely.
Yeah.
We're majority now from different countries.
Right.
So they come here assuming that
That is the
not
case.
realizing that we are a completely different legal-based system.
Right.
Mm-hmm.
And it's a very costly mistake, unintentionally,
Right.
where it now becomes generational, where you keep having to go to probate court every generation, and your assets keep dwindling and dwindling as your legacy, rather than the opposite of having your assets keep accumulating generationally, which is so important for when you come to this country.
That's right.
Yes.
And that's where, as an advisor, and it's working closely with an attorney, with the client is so important because that's where I want to make sure that clients' assets are not being all spent,
Yeah, dwindle down.
right? Not following the grantors.
So sorry, I thought I put this on silent.
That's okay. That the money is spent or given down to the heirs as intended by the grantors, right? The people who are giving the money out to or inheritance to. Let's go to the second episode or second case where it's now a little more complicated. Say that I live in Georgia. I own a primary home. I own a second home in Florida, right? I have a few children. Let's just stick with one marriage because they can create. And I also have rental properties in multiple states. Let's say Florida, California, for example, New York, right? And I own two companies. One's partnership, one's an S corp.
That's a lot. We need an hour.
Let's just cover the very top
Let's
layers.
break down the assets one
Okay.
by one.
Okay.
That might be the easier way to digest this.
Okay.
So let's start with the primary home. Again, we discussed in the previous example of who's on title,
That's right.
and even if both on title, is there right of survivorship language on it? Those all have different scenarios and may involve probate. And also the other real estate in different states, you have to probate that also in the state that the property is situated.
Right. Each property.
Each state. You have to open it in the state you reside, Georgia. And then you have to open ancillary probates in all the different states that you have assets in. So you can, probate can take 1 to 2 years or more. Average expense is 5 to 15% of the asset value. It can, so double that, triple that, quadruple that.
Right.
Because you got to do it in each different state. And you got to hire lawyers in each of those different states.
Oh, wow.
Some will take a percentage. Already embedded in the law,
Yeah.
you have to pay them percentages.
Okay.
Others will pay you flat fee. These kind of things, lawyers don't generally charge hourly. They'll do flat fee or percentages. So there you go again. We got probate courts in multiple states. Now, companies like LLCs and S corps, again, husband and wife, if you're both on title, you still don't inherit the deceased's half. So if you ever want to liquidate and sell that property, you got to have the other partner alive. If not, where do you have to go? Probate court.
Right. Okay.
All right? Even if only one person's on title and that person dies, got to probate it.
Yes.
There's no way to designate a beneficiary or transfer title with companies. There's just no way.
Right.
You have to do a trust. You're very familiar with trust. And that's the only way to really transfer companies without probate court.
Especially when they have assets. Is that what you're referring to?
Yeah, with companies like
Right.
LLCs and S corps.
Right.
Then let's talk about partnership shares. And that'll, again, there's no way to transfer that.
No.
You can't put in an operating agreement, I designate my shares to go to my husband.
No.
There's no law in the United States that allows that. So again, your surviving spouse then has to probate that unless you had transferred those shares into the
Right.
trust while you were alive.
That's right.
And is there any other asset I'm missing here?
So the question then is, well, if I say I go to you, right? I'm the one. So I go to you and I go, okay, Holly, so I'm going to create a trust that you recommend. So then I put, let's say, all these properties outside of Georgia. I put the title, right, or change the title to the trust. Then do I have to create trust for each state property separately? This is what people ask too. So, or is one trust, for example, let's just say we create a living trust. Can I just list them all there? And then I don't have to go through probate court of each state?
So let's work backwards. One, just listing your assets in the trust document doesn't mean that it's part of the trust. You actually have to retitle the trust.
That's right, fund it.
And or designate also all of your accounts of beneficiary as the trust. So that's number one.
Right.
So we have many people in probate court that designated or listed their assets and thought, I'm done.
Right,
In fact, the document doesn't mean anything.
right.
So you do have to retitle the assets in the trust name when you create the trust. Again, why you need expert to do that. So, but again, with the trust document, you have to integrate all of your assets. How do we do it? Right? We have to retitle the primary home.
That's right.
All of the other properties in the different states, you absolutely want to retitle it
Right.
into the trust name to avoid probate court in every state that you have assets. And assigning the LLC and S corp. S corp,
trust.
yeah, S corp's unique. There's different ways to do it, but then all of your assets automatically transfer to the person you listed in the trust document.
Okay.
All of those assets.
Right. And one trust can take care of all these different
It
properties.
can.
Yes.
Some people have this misguided, and depending on what your purpose is, you don't have to do a separate trust per LLC.
Right. That's true.
You're already getting the corporate veil protection by having the property in separate LLCs.
Right.
So you're kind of duplicating what you're already getting protections in single purpose LLCs.
That's right.
And the one trust document would be like the parent company concept, where it can own all of the subsidiary LLCs.
Right.
And it pours into, for purposes of transfer at death, through this trust document with the probate court. All your primary home, all your properties in different states, your LLC, your S Corp, all of that can be transferred by title automatically through the trust document.
That's right.
But you got to integrate everything with the trust.
And all of this is businesses that you have in the U.S. If you have anything outside the U.S., that's something separate?
Yeah, you have to follow that country's rules.
Okay.
The United States, as much as they want to rule the universe, they have to still follow the U.S. citizens in this whatever country the asset is in.
Okay.
Yeah.
Oh, that's
U.S. is losing its influence.
Well, but we're living in a time period where we get to live in the best country in the world.
That's for sure. I mean, absolutely. I agree with that.
Yeah.
We can certainly do a lot better.
Yeah.
No. So, I mean, the question you're asking is because you have a lot of clients who have different things outside of the U.S., right?
Yeah. And I guess the other thing I was going to ask was about, how does it affect tax-wise? And maybe we'll have to talk about that on another occasion.
But if it's pressing question, ask, and so we can.
Okay.
Yeah.
Well, yeah. I mean, I guess what is concerning to some is is it better to do the will as far as tax is concerned, and how is that going to affect will versus the trust, and how is that going to affect those who are inheriting those assets?
As far as tax is concerned, no, it doesn't. It doesn't make any difference. In other words, if you have big enough of an asset that goes over the lifetime exemption amount, then there's tax consequences, right?
Okay.
You may need to file your tax return and things like that. But as far as tax being assessed, it's no
For
different.
most people, majority of people, the tax doesn't change because of doing a trust
Right.
versus a will.
Okay.
Your life stays the same. You owe the same taxes
Got it.
whether you have a will or a trust at your death for most people,
Right.
other than those that are above the estate tax exemption amount that
Exactly.
Joyce discussed,
Yeah.
which
There's quite
currently
a
it's
lot.
at 13 million.
Yeah. Well, I think it's going to
Almost.
go down though.
Yes, January 1st, 2026,
It's
it
gonna go
sunsets
down.
back down to 5 million.
Right. So for those who are concerned about their assets growing, right, the value of their assets growing, this is a perfect time to talk, right?
Yeah.
Because you want to definitely take advantage of the higher exemption amount that's available right now. Because after 2025, we don't know where it's going to go. I mean, people make assumptions or their predictions in terms of like how much it's going to be. And they're like, well, 6 million, 7 million, but who knows, right? So.
Well, it's definitely going to go down to 5 million. I don't think that's going to change.
Yeah.
Whatever
Unless
the
somebody does
politics.
something.
Well, I'm just going to tell you, it's going to drop down substantially.
Okay.
Whether it's going to go lower than that depends on the makeup of Congress and the president.
I don't think it's going to go lower than 5-6 mil though.
Yeah, but so yes,
Perfect
you're
timing.
right. They should be grandfathered in for those that do have assets above 5 million because it's a 40% estate tax.
Whole lot. So, gosh, time flies.
Yeah, it
When we're
does.
having fun.
That's right.
Yeah,
like
that's
time
a
is
lot of
up again.
information.
Yeah, we have to wrap up again.
Yeah.
So I'm sure, we're gonna try to invite you again.
Thank you.
Yeah.
Talk more about these things because I know it takes time to. And repetition really helps in terms of
Yeah.
understanding new concepts and how
Yeah.
it works and things. And you kind of have to know enough to take any action, I think.
Right. I really hope that the viewers will appreciate this information, and if they have questions,
Yeah, jot it down.
write it, send us some comments so that maybe we can have some questions to ask you next time you're with us.
I know, and Soshana is really good at following up. She's like tech queen, so she does use all kinds of different gadgets and things like that. And so, any questions, send us, and we'll try to address it as much as
Absolutely.
possible. And thanks for joining us today, and we really appreciate your attention. And till next time, have a good time.
Take care.
Thanks for watching this week's video. If you have questions on anything we covered, or you'd like to ask us, just leave it in the comments below. We love to hear what you have to say about what we talked about and what you want us to talk about. Please like us on Facebook, follow us on Instagram, and subscribe to our channel. See you next time.